Thank you for clicking the link and continuing with the video series. And now we're going to talk about the third secret to great estate planning. And this is how to structure your estate planning strategy to create a lifetime stream of income from your retirement accounts to your adult children while protecting that stream of income from creditors, lawsuits, divorcing spouses, as well as other predators. Now, you may have heard of the rule that your IRA is protected from creditors during your lifetime, which is true. However, these rules do not exist when you leave your retirement account to your adult children after death. Due to the Supreme Court's ruling in the Clark case, the inherited retirement account is vulnerable to creditors, including divorce claims, bankruptcies, lawsuits, as well as other predators. Now, you may have also heard of the IRA distribution rules, and the most common rule being that when you reach age 70 and a half, you are required by the IRS to begin withdrawing from your IRA what is called a required minimum distribution, or an RMD for short. Again, this rule is completely different when you leave your retirement account to an adult child or other beneficiary at your death. Now, when you leave an IRA or other retirement asset behind after death, your adult children will usually be given three options depending on when they inherit the asset and what type of retirement asset it is. They can withdraw the entire balance, they can withdraw the balance out over 5 years, or they can withdraw their RMDs beginning December 31st of the following year, not beginning at age 70 and a half like you did. In addition, the retirement account is subjected to creditors, divorcing spouses, lawsuits, as well as other predators. It is not protected in any way, shape, or form. But let me share with you a troubling statistic about retirement accounts and inheritance. Nearly all inheritances, the recent statistic said 70% or more, is going to be spent within 17 months after death. Most of the time, honestly, it's within 6 months. So let me tell you the story about Bill and Dan. Joe, their father, died with an IRA valued at $450,000 and left that IRA to Bill and Dan in equal portions. Now, Bill and Dan were given the option of withdrawing the entire IRA at once over 5 years, or taking their RMDs based on their life expectancy beginning December 31st of the year following Joe's death. Now, given the statistics, it's safe to assume what Bill and Dan were going to do. They were going to spend through that IRA, and they were going to spend through it within 17 months. However, can you guess how much the IRA would be worth to Bill and Dan if Joe had established a standalone retirement trust? Well, the withdrawals over Bill and Dan's lifetime would be approximately $2.9 million each. Yes, you heard that accurately, $2.9 million each. Now, of course, this is assuming many variables, including expecting a 4% return annually. Now, we are going to cover this type of estate planning strategy in much more detail during the webinar, the Standalone Retirement Trust, which allowed to stretch out those distributions up to the IRA to Bill and Dan, and would also protect the balance of the distribution from divorcing spouses, creditor claims, lawsuits, as well as other predators. It's a very powerful estate planning strategy. It's also very difficult to understand because there are a lot of different rules that apply. But in our experience, families that have that IRA or retirement asset valued at above $150,000 really need to consider this type of planning. But again, we're going to talk about this in much more detail on the webinar. But that's it for now. We've just wrapped up the 3 videos on the 3 great secrets about estate planning. So go ahead and click the link below, enter the webinar room. I'll see you there, and I hope you enjoy the webinar.